Today I'm going to go over something that sits right at the intersection of law, property rights, reconciliation, and the economy of British Columbia. And the reason this matters right now is because the legal ground underneath all of these are shifting at the same time. If you own property, if you build housing, if you invest in BC, or if you're part of a First Nation navigating these systems, the common thread right now is uncertainty. And that uncertainty isn't coming from one single court case or one single law. It's coming from multiple legal and regulatory pressures that are all colliding at once. BC is trying to walk a very narrow tightrope. On one side, it has binding legal obligations to align provincial law with Indigenous rights, including commitments under DRIPA. On the other side, it has an economy that depends on legal certainty, predictable land use rules, and clear property rights. Right now, those two forces are creating real friction. I'm not going to go too deep into detail on the other court rulings I've already covered in different videos. I've already done videos on the Cowichan decision, how BC courts are diverging from other provinces, and the mineral tenure issue. Those videos are already out there and I'll link them below as well. What matters today isn't the fine details from those rulings, but the pressure they've put on the province to respond. And that response is where things get very real very fast. One of the province's main responses has been a proposed overhaul of the Heritage Conservation Act, or HCA for short. To be clear right away, much of this is still in the proposal and consultation phase, and the final details could change. But even at this stage, the direction is clear, and it's already generating serious concern across homeowners, municipality, industry, and First Nations alike. Historically, the HCA focused on protecting physical, identifiable heritage sites. Things you can physically verify. Artifacts, archaeological evidence, and burial sites. There were known processes, known areas of risk, and ways to understand potential constraints before committing money and starting construction. The proposed changes would expand how heritage is defined to include not only physical evidence, but also Indigenous values and what's often described as intangible heritage. That includes oral histories, cultural landscapes, spiritual significance, and ceremonial connections to land. This is not about whether those things matter. The issue is how you build a regulatory system that is fair, enforceable, and predictable when the subject matter isn't always visible or easily mapped. Under the previous system, certainty usually existed earlier on in the process. You could often identify known risk areas before applying for permits or before financing was locked in place. Under the proposed approach, critics worry that uncertainty could surface later on in the process, depending on how the rules are implemented. Because some cultural significance may not be apparent to a property owner or a developer based on publicly available information. That distinction matters because timing is everything when it comes to real estate and construction. Financing, contracts, and schedules are built around predictability. Even modest delays can derail projects when the margins are tight. And when uncertainty appears late in the process, it's not just an inconvenience, it can potentially be very expensive. Now, I want to pause here because this is where the public conversation tends to go off the rails, and I've seen some pretty concerning comments in some of my previous videos about this topic. This is not everyone versus Indigenous people. This is not a story about First Nations taking land. And framing it that way is not only wrong, it's actively harmful. These regulatory changes are affecting First Nations as well. In fact, one of the clearest signs that the system is breaking down is that First Nations are now suing the provincial government over how consultation and negotiations are being handled. This isn't a unified bloc on one side and everyone else on the other. This is a government that's struggling to design a framework that works for anyone. Private landowners are dealing with uncertainty about what they can build. Developers are dealing with expanding approval timelines and financing risk. Local governments are worried about basic infrastructure grinding to a halt. And First Nations are raising concerns about inconsistency, secrecy, and unequal treatment in negotiations. province. That's not reconciliation failing, that's governance failing. When frustration gets misdirected towards Indigenous communities as a whole, it obscures the real issue, which is that poorly designed regulation helps no one. It undermines public trust, fuels resentment, and ultimately threatens the very reconciliation efforts it claims to advance. You will hear concerns from mayors, builders, and industry leaders across the province. And while their perspectives differ, the core message is remarkably consistent. When rules become too broad, too subjective, and too unpredictable, everything slows down. Not just housing projects, but roads, utilities, schools, and essential public infrastructure. From a legal standpoint, there's a critical distinction here that often gets lost in political debate. Laws function on clarity. Physical evidence can be verified, it can be mapped, it can be assessed using established methods. Intangible claims, by their very nature, cannot be evaluated in the same way. That doesn't make them unimportant, but it does make them extremely difficult to regulate without creating uncertainty. When enforceable legal obligations depend on claims that cannot be independently verified or clearly bounded, predictability tends to disappear. And predictability is not a luxury in an economy, it's a requirement. The province argues that this approach is meant to reduce conflict in the long term by addressing potential issues up front, rather than dealing with lawsuits or stop work orders years into a project. That intent here matters. But intent doesn't eliminate risk. If the upfront process itself becomes so open-ended that no one can assess costs, timeline, or outcome in advance, then the system may prevent future conflicts by preventing projects from happening at all. The province has also framed this overhaul as a disaster recovery issue, arguing that communities rebuilding after wildfires and floods run into lengthy heritage processes under the current system. And in theory, that logic makes sense. Lytton, which is a town in BC that burnt down in a wildfire in 2021, is the example the NDP points to, and that's understandable. But it's also important to acknowledge that Lytton is a very specific case, not something we've seen replicated at scale across the province. And that brings us back to the paradox that BC is now facing. The courts have made it clear that Indigenous rights must be meaningfully respected. But at the same time, legal uncertainty at this scale could potentially threaten economic stability, housing supply, and investment across the province. When certainty collapses, everyone loses. Property owners lose confidence, developers pull back, infrastructure slows, and First Nations are left navigating a system that creates more conflict, not less. Even the province has acknowledged that this is an unsettled area of law, that proposals have been abandoned or rewritten, and that the balance is incredibly difficult to strike. That honesty matters, but it also underscores how fragile this moment is. So the real question isn't whether heritage should be protected or whether reconciliation matters. The question is, how can BC design a regulatory system that respects intangible cultural connections to land while still preserving the legal certainty that property rights, investment, and reconciliation itself ultimately depend on? So if you're wondering how any of this could affect your property, project, or your specific situation, there's a Calendly link below. You can book a call and we can go over it together. What are your thoughts on the proposed HCA amendments? Let me know in the comments.